You build a real estate portfolio worth millions, properties that you bought smart, rehabbed right, and rented for years, but then one day, a process server shows up with a lawsuit and suddenly your equity isn't your retirement plan anymore, it's bait. And if you're not protected, it's the first thing the court will sink its teeth into. So here's the question: what if you could make it look like there's nothing to take without losing control of your properties? That's the power of equity stripping. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And for 34 years, I've helped high net worth individuals, business owners, and investors protect themselves all over the U.S. and around the world, what they've worked so hard to build. And for nearly 30 of those, I've been setting up Cook Islands Trusts, arguably the most powerful asset protection tool in existence. In fact, our firm has set up more of them than any organization on the planet. But today, we're talking about something most lawyers don't understand, and that's equity stripping, especially when combined with offshore strategies, is a secret weapon in lawsuit defense. And if you want more advanced strategies like this, hit the subscribe button if you haven't. We go deep here. So let's define it. Equity stripping is the process of removing visible equity from your real estate by placing liens against the property that you own, either through legitimate loans or carefully structured instruments. So here's why it matters. When a lawyer does an asset search, what do they look for? They're looking for this equity, right? That's the jackpot. They want to know what can be liquidated. So if you show up as owning 3 properties with no mortgages or worse, paid off, you're a lawsuit magnet. But if your equity is tied up in legal instruments, mortgages, notes, liens, then you look broke, unappetizing, a dry well. And contingency fee lawyers? They skip dry wells. Let's compare to investors. Sarah lives in California. She's got 3 rental properties, about $2.7 million in total equity. One day a tenant slips on a wet tile, breaks a hip, and sues. The tenant's attorney pulls up the property records and says, jackpot, $2.7 million in reachable equity. So Sarah gets dragged into court, spends months in litigation, and ends up settling for a massive sum well beyond what her insurance covers. The properties, she had to refinance under duress to come up with the cash. Okay, now meet Mike. Mike worked with us, same number of properties, similar equity before we got involved. We helped Mike strip the equity by placing 90% liens on each property through a legal structure. When a different tenant fell down his stairs, a lawyer did a quick asset search and saw 3 properties with just 10% equity. And that barely covers the closing costs. So the attorney passed. The tenant settled with the insurance limits. Mike slept like a baby. 2 people, same assets, different outcomes. So how do we do equity stripping? Now let's talk mechanics. Here's how we perform an equity strip the right way. Step 1, privacy first. Land trust. So we start by transferring each property into a land trust, and this masks your name from the public property records. It doesn't eliminate liability, but it confuses the paper trail and adds a layer of obscurity. Now it's tax neutral, and you retain control. Step number 2. We set up an LLC, a limited liability company, to be the beneficiary of the land trust. So this helps keep liabilities from passing through to your personal balance sheet. It also creates a barrier between you and potential lawsuits linked to that property. Step number 3, the strip, strategic liens. Now here's where the real protection happens. We record mortgage liens here, payable to this LLC. We record mortgage liens against the property, often up to 90% of its value. And these liens are typically payable to an offshore LLC that you control through your offshore trust. We can do it domestically, but offshore is stronger protection for you. On paper, your equity disappears. In practice, you still control the structure. So here's the best part. You can still refinance, sell, or rent the property, so nothing about this interferes with the operations. Okay, next, what about your personal residence? Okay, since you asked, let's answer that question. Your home is special. It's where you live, and it qualifies for tax benefits that are different than the tax benefits for rental property. First of all, the mortgage interest deduction. Next, homestead exemptions. Another benefit is the capital gains exclusion on the sale. $250,000 if you're single, as of this video, and $500,000 if you're married and filing jointly. So we take a different approach. Now, we still use the land trust for privacy of ownership, but instead of naming an LLC as the beneficiary of that land trust, which could jeopardize the tax benefits that we just talked about, we leave the beneficiary as you, or sometimes your revocable trust. And then we place a home equity line of credit lien here, payable to an LLC, and this could be a Wyoming LLC or preferably an offshore LLC that you own. So you keep the tax perks, but if somebody searches for equity, they'll find it's already claimed. So let's get real. Equity stripping is good. Offshore equity stripping is great. Why? Because U.S. courts can't compel a foreign trustee company, especially in the Cook Islands, to hand over your assets or enforce a judgment. So here's how we set it up. We create a Cook Islands trust for you, represented by this purple rectangle. Inside, we put a Cook Islands LLC. You're the initial manager of that LLC until a lawsuit strikes. When the legal heat shows up, our licensed bonded trustee company law firm steps in, and they can shield everything. So it's like having a fire extinguisher on the wall. You don't need it until you really need it. And remember, we've set up more Cook Islands trusts than anybody in the world, so we know how to do this right. So now combine that offshore trust structure with the equity stripping strategy. You just made it 10x harder for anybody to touch your real estate. Want to go to the next level? Let's talk about monetizing the liens. So we record the mortgage lien, but then we work with a third-party lender, somebody who's already friendly to the cause, to actually purchase this mortgage note. And the proceeds, the funds from the mortgage note, go into your offshore trust. So now, not only is your equity gone from public view, it's been converted into liquid assets sitting in a Cook Islands trust where U.S. courts can't reach. So think about that for a second. You've just removed the equity and moved it into an offshore trust, and the asset is no longer just protected, it's gone legally and safely. And even better, courts and financial institutions see it as a legitimate transaction because it is. Okay, now what if you need the equity later? Let's say you want to tap that equity again. You can, because remember, that offshore trust is yours. It holds the LLC. The LLC holds the mortgage notes, and if no lawsuit is active, the manager, you, can refinance, repurchase the note, because remember, the cash went offshore, probably have it in stock market investments or index funds, and you can redeploy the capital. So the protection is flexible. So you're not locking up your wealth. Instead, it's locking out your enemies. Now, some people ask, is this legit? Let me be clear. Absolutely. This strategy doesn't involve hiding anything. And we've done this thousands of times. Like I said, I've been doing this for 34 years. Everything is recorded publicly. Mortgages, land trusts, LLCs, it's all traceable. We're just changing the appearance of the value, the way it looks to the outside world. Most importantly, we're acting before there's a lawsuit. Courts look much more favorably on pre-threat asset protection than scrambling after the fact. And that's why timing matters. If you wait until you get sued, it's often too late. There are ways we can still protect you, but it's going to cost more and it's going to be more scrutinized by the court. So when is the time to act? When the waters are calm. So the next question, what if you get sued anyway? Now, you might be thinking, what if I do all this and I still get sued? And that's a great question. So we'll cover how offshore trustee companies and trigger events protect your assets during the active litigation in an upcoming video. But the short answer is, if structured properly, the creditor will hit a legal wall. And even if a court tries to pierce the veil, good luck convincing a foreign trustee company in a jurisdiction that doesn't recognize U.S. court judgments to hand over your assets. So at the end of the day, here's the truth. You worked hard to build your portfolio. You deserve to keep it. Equity stripping isn't about hiding. It's about smart legal structuring. It's about using the tools that billionaires and banks use before the threat shows up. And that's what we do at Asset Protection Planners. And if this strategy sounds like something that you'd like to take a look at, something you want to place before your next tenant slip and fall, or your next business deal turns sour, feel free to visit us at assetprotectionplanners.com. You can get a whole lot of free information there. You can fill out a free consultation form if you're serious and not just curious. And if you have $500,000 or more in assets, that's our specialty. Or you can give us a call at 1-954-400-1050. We've been doing this for over 30 years, and our team can structure your equity strips, set up land trust, your LLCs, your offshore accounts, everything. And when your property looks like dry wells, predators look elsewhere. So don't leave your equity hanging out there in the open. Protect it, strip it, secure it. I'm the business guy, and thanks for watching. And hey, remember to subscribe if you haven't. Click like. It really helps me out a lot. I really appreciate it, because the best lawsuit is the one that never gets filed.